I'm Duncan Field, and I'm here with Lucy Thomas, who's just delivered a paper to the Oxford Conference on compulsory purchase and the decision of the Secretary of State in the Aylesbury estate regeneration case and what that might mean for future estate regeneration schemes. Lucy, one of the issues that came up in the discussion after your paper was around the forum which is most appropriate for sorting out some of these issues, and the point was made that perhaps the inquiry forum and the inspector presiding over that forum isn't really the best way of doing that. Did you have any further thoughts?
I think I thought it was a very good question that was asked, and I think there's always going to be some concerns over the inquiry process because of the nature of the way that is put together. It's very often the case that the issues that are going to come forward in the inquiry to be discussed are just those that have been raised by objectors or those that have been raised by those promoting the compulsory purchase order. It won't necessarily be all of the issues that the Secretary of State is going to need in order to be able to make his or her decision. So if those issues haven't come up throughout the inquiry, then that evidence and the thinking around them doesn't particularly get tested, and then it's just going to be left to the Secretary of State to make that decision based on the paperwork in front of him. And then of course, if he hasn't necessarily got all of the information or he hasn't got the full rounded picture in front of him, then that's going to affect the quality of his decision making.
Have you seen mediation used in any of the schemes you've been involved in, and if not, do you think that should be something that promoting authorities should explore?
I personally haven't seen it actually used within a compulsory purchase context. I think that could be quite a good idea because that would allow particular topics to be picked and discussed that were actually relevant to the decision making, rather than, as I say, those issues that have just happened to have been landed upon by particular objectors or those that the promoting authority wants to put in front of the Secretary of State. So if you had a more mediation type context, that could be quite good by setting an actual agenda to go through the various issues that need to be considered and that are very relevant to the decision, to make sure that those all get properly discussed, and any objections or any extra information that's relevant to those points could all be brought forward then, which would ensure that the Secretary of State had everything in front of them that he needed before he had to make his decision.
And do you think that might be a way of dealing with this, it seemed to me, extraordinarily complicated issue of finding the right rehoming solution for residents? In other words, you mentioned, I think, in answer to one question, that one housing solution might adversely affect some special interest groups more than others. Would mediation be a way of finding those individual solutions, or do you think that's just too much of a burden for a promoting authority to explore?
I don't think it would be any more of a burden than the situation that they're currently in, which at the moment I think best practice would suggest that they did go and speak to people on an individual basis to properly understand what the impacts were that somebody was going to be facing and what the best solution for them was going to be. So it could be that a mediation solution whereby all of the different options were explored and considered might be a more efficient way of doing it than the current situation. Although that said, I think there's always going to be a place for people being spoken to on an individual basis to really understand what the impacts on them are, because I think it'd be quite easy as an authority to assume you know what those impacts are, and until you've actually spoken to people and really got to the background of why they're upset about the CPO, you're not really going to understand exactly what it is that you're going to be able to do to help them. But I can see certainly some merits in terms of time and efficiency by going through all of the options that can be offered by the authority and then working out whether or not, maybe in a slightly more abstract fashion or through bringing people in and actually interviewing them and discussing those with them, whether any of those options would be suitable.
One of the issues that also came up when we were talking about rehoming options were consequences for viability of schemes and the attractiveness of the schemes to joint venture partners. It struck me that elsewhere in planning, when viability is marginal, we sometimes have the concept of enabling development. Do you think that might have mileage in estate regeneration schemes, or?
I suppose, I think that would really come into the planning of the estate regeneration scheme itself, and to see whether or not actually, yes, in terms of that viability, are there going to be options. So if the viability of a scheme was going to be detrimentally affected by the need to actually provide more compensation or more generous rehoming offers, then I think that's something developers need to start looking at much more earlier in their schemes. And then yes, if that is genuinely going to affect whether or not that scheme is going to go forward, then of course then explore other options that might enable the scheme to come forward. It sounds like that's something that really does have to happen very early doors when the scheme's first being planned, because that's going to need to get worked into the planning solution as well as the land assembly solution.
We obviously focused more on the estate regeneration cases, but I think you were quite careful to draw out lessons which have wider applications for other compulsory purchase orders. And we talked briefly about the impacts on businesses, and you mentioned small businesses and how they needed to be taken into account. What about landowners and investors as well? I mean, is there an argument here that actually local authorities need to be more careful about allowing them an opportunity to participate in regeneration schemes outside, the estate regeneration context?
So allowing those that have got a significant landholding to actually participate within the redevelopment scheme. I think there can be scenarios where that's quite helpful, and I think certainly a lot of the old CPOs back in the day were very much based on those that had a significant landholding would then be the person that was forefront likely to be delivering the scheme, and then the CPO would just be supporting them in assembling any remaining interests that were needed. I suppose now authorities seem to be looking at things slightly differently in that they are actively looking for opportunities within their areas for developments, and those that actually happen to own the land is somewhat of a second consideration afterwards when they're working out what's the best development for this land. So I think land ownership is always going to be very important, because obviously if you can strike a good deal and you can get certainty of delivery with the particular landowner, then subject to making sure that you've complied with any state aid and procurement obligations that might arise out of that, then working with them has got to be an easier solution. But I think the difficulty that you're going to face there is a landowner that holds land that hasn't yet developed it. What are we going to say that's going to make them bring that development forward? So where are you going to get your certainty of delivery and certainty of timing of delivery? If you're leaving it much more to the landowner to bring it forward than you are as an authority taking control and trying to assemble the site to bring it forward yourself, or taking it to the market and going through a JV or a development agreement process.
We talked about compensation. I've seen, and I'm sure you have, voluntary schemes where promoters offer 125% market value, for example. Is there a case for that becoming a standardised approach, and what could government do to encourage that?
I think in the light of Aylesbury, it's definitely going to be something that developers and acquiring authorities are going to look much more carefully at, in terms of whether the compensation package that's being offered is actually something that, if tweaked a little bit, it could actually make a very big difference to the successful outcome of the CPO. I can certainly see developers going forward possibly looking not just at what is the market value of the land and an estimate of what they think the Lands Tribunal might award. If were it to get to that point, if compensation can't be agreed between the parties and it gets referred to the upper tribunal, that tends at the moment to be the basis upon which most developers and authorities base their compensation claims. I can certainly see advantages to maybe looking at slightly different scenarios. Again, it's going to be a matter of whether or not you can build that in very early into your scheme. It's going to be difficult to expect a developer to suddenly increase their land costs if they've based their planning viability on a much lower land cost based on just market value. To expect them to, as you say, add, say, 25-30% to that in order to avoid the CPO inquiry, that's something that they're going to have to look at very carefully. And so it's something that I can see local authorities that are promoting development opportunities, it might be something that they have to put out there to developers in the first instance to explain that those are the terms on which they want to take this scheme forward.
Okay, Lucy, well, thank you very much for your paper today and for this discussion afterwards.